we're going to now talk about a revocable living trust. Everybody, I'm sure, has heard that term, revocable living trust. One of the things that I want you to know about estate planning is you hear the term trust a lot in different ways. When we say, well, who should you appoint under your power of attorney? I say, appoint somebody you trust. I'm not using that term in the way of revocable living trust. So that's confusing. When you hear the term trust, you'll hear revocable living trust, you'll hear irrevocable trust, you'll hear testamentary trust, you'll hear special needs trust, supplemental needs trust, asset protection trust, Medicaid gifting trust. So all of these terms mean something different. And that is why when somebody says trust, that's just like, okay, let's ask more questions. What kind of a trust is it? And frankly, most people don't even know what kind of trust it is, and they don't know what it says or how to administer it. So let's kind of step back a moment. Revocable living trust, what is it? It is a trust. Okay, what's a trust? A trust is a legal document that is signed that says that this legal fiction, so to speak, can manage assets through its trustee. So let me give you an example. Let's say I create a revocable trust. I am the grantor or the trustor. I'm the one who signed the document. Well, I want to be the trustee because I want to manage my own money until I can't. So I am the trustee. And guess what? It's all for my benefit. So I am the beneficiary. I wear all hats when it comes to a revocable living trust. And if I change my mind for whatever reason, I can say, I don't want this trust anymore, and it goes away. So that's one reason for confusion. Why did you have this trust in the first place? The reason that you had this trust was because you said, I want to avoid probate. A revocable living trust, if done right, will avoid probate. So I want to avoid probate. I want to make sure that my house goes to my kids and they don't have to do a probate. Okay, so I set up the revocable living trust. I need to do a deed where I transfer the title of my house from me to the trustee, who is me, so me as trustee. And then on my death, my house then goes to my kids because they're now the next beneficiaries of the trust, and one or both of them will be the trustee, so they can sell the house or do whatever they want with the house, all without the need to go to a lawyer or to do a probate. And so people really like this idea because they can do it themselves. And that's where people get into trouble, because when you try to do legal stuff yourself, you don't understand what you don't understand, don't know what you don't know, and you can get into problems with it. Revocable living trusts, I would say more often than not, when clients bring them in, it's clear that they didn't understand it or what the consequences are of doing it or how somebody would administer it after them or when they're gone. And so basically they were told, hey, this is your end-all solution, just get a revocable living trust. They do that. They can, get them fairly inexpensively, either themselves or, $1,500 to $2,500 or so for the trust. And they feel like, okay, this is cheap, this is good. And they don't get any legal counsel or legal advice, and they don't know what is going to go on with the trust. So that's one of the problems. I do want to point out, as you can see on my screen here, that in Washington, revocable living trusts provide no asset protection for a surviving spouse. So if you wanted to make sure that when you go, your spouse can have money and it won't all be spent on a new spouse or on creditors or, financial exploitation or some kid, twisting his or her arm, or more importantly, long-term care. We see this a lot. You're likely not going to want to use a revocable living trust type platform for your estate plan. And by the way, if you do have a revocable living trust, you know that you also have what's called a pour-over will. What is a pour-over will? Why is it called that? A pour-over will is intended to capture all the assets that you forgot to put in your trust because you didn't know and the lawyer didn't help you, or they helped you way back when, but 10 years have gone by, you opened up a new bank account or you bought a new house, you didn't put it in the trust. So the pour over will means that on your death, there will be a trust administration, but first there'll be a probate to capture all the assets you didn't put in the trust that you should have. They'll go through probate and they will pour over into your trust. So basically you tried to avoid probate, but you ended up having a probate plus a trust administration. So revocable living trusts, don't get me wrong, they serve their purpose and can be a very good estate planning tool. But I think more so with a revocable living trust than any other kind of estate planning type platform you have to understand it. You have to understand what you need to do with it, what you're giving up, how it works, and involve those people who will be the successor trustees. And I would say, talk to a lawyer when you don't know what you're supposed to do. You should be able to go back to that attorney that helped you with that revocable living trust, and you should expect responsive, helpful action. Will they charge you? Probably. I mean, that is the trade of attorneys, is that we charge for our advice, for our time, for our services. And that's one of the reasons people don't want to go back to lawyers. But if you want it to work correctly, go back to the attorney that drafted it and expect that they will help you, because that is what they should be doing, in my opinion.